All right, so it looks like just about everybody has kind of got connected and cycled into the room. Again, I'm Anthony Gonzalez. I'm the program coordinator with the Higher Education Center for Alcohol and Drug Misuse Prevention and Recovery. I want to thank you all for joining us today for our webinar titled Drug-Free Schools and Communities Act, Cannabis Legislation and Updates and Impacts, featuring Adam Jessel. But before we get started, I have a few housekeeping slides I'd like to review. We do welcome your questions, and please feel free to submit them at any time throughout the live presentation. You can do so through the Q&A box found at the bottom of your screen. Please submit them in the Q&A box, as questions that go in the chat can sometimes go overlooked, and we don't want to miss any of your questions. There is live captioning available for this session. You can set that to your likings through the taskbar at the bottom of your screen. If you have any trouble with that, please feel free to send us a chat, and I'm happy to get you set up. We encourage you to learn more about becoming a member of the Higher Education Center. Here we just have a breakdown of the different tiers and the benefits of becoming a member. And of course, you can learn more by visiting our website at hecaod.osu.edu. And with that, it is my great pleasure to introduce you today our presenter, Adam Jessel. Adam serves as the Dean of Students for the University of Wisconsin-Milwaukee. Before UWM, Adam was Assistant Dean of Students and Director of Student Conduct and Community Standards at Washington State University. Adam received his Juris Doctorate from Seattle University and his Bachelor of Science in Business Information Systems from California Lutheran University. Thank you so much for joining us, Adam, and it's my pleasure turning it over to you at this time.
Thank you so much, Anthony, and good afternoon, everybody. I'm so grateful to be here and that you've invited me into your space and with your community. Hello from gorgeous Milwaukee, Wisconsin. It's sunny, it's 50 degrees out, which is an oddity for mid-December, but I'm just so thankful to be here. As Anthony mentioned, I got my Juris Doctorate at Seattle University, and then before jumping over to Student Affairs, was an Assistant Attorney General for Washington State University before taking the position in the Director of Student Conduct role. With that, every good lawyer has to come with a waiver or a caveat, so just wanted to let everybody know that anything I say today doesn't constitute legal advice. You can all laugh at that, but it's something I feel like I need to say at the beginning of every presentation. So thank you again so much for having me. So what are our goals today in our overview? Just a second here, I'm going to try to advance the slide. There we go. So we're going to talk a little bit about the Drug-Free Schools and Communities Act. Specifically, we're going to talk about the requirements and the legal requirements for the DFSCA, as well as how recent cannabis legislation impacts those requirements. I hope today to give you a little bit of a broad overview of the Drug-Free Schools Communities Act, why it started, where it started, but then also answer some specific questions relating to cannabis legislation. We will talk today a little bit about prevention, enforcement, so hopefully get into that later in the presentation. But the first bit is really to talk about the Drug-Free Schools Communities Act and how we got here. So with that, a little bit of an origin story. The Anti-Drug Abuse Act of 1986. So this is really in the heart of the war on drugs. And that act created the Drug-Free Schools and Communities Act. And the intent of that act was to strengthen federal efforts in eradicating illicit drug crops and to halt international drug traffic and improve enhancement of enforcement of federal drug laws. So that is where the Drug-Free Schools and Communities Act was created. It was nested inside the Anti-Drug Abuse Act of 1986. And then literally 3 years later, Congress amended the DFSCA, which was signed by President George Bush. Those amendments heightened the scrutiny on institutions of higher education as far as enforcement of the Drug-Free Schools Communities Act. And so, as you can see on my slide here, the amendments required that any institution receiving funds or any financial assistance from the federal government had to certify that they had adopted and implemented programs to prevent, alcohol and drug abuse. If you're looking around, if you're a legal geek like myself, the finalized regulations for the DFSCA are codified in something called EDGAR, which is the Education Department General Administrative Guidelines. Now, we'll talk about societal shifts a little bit later. The Anti-Drug Abuse Act specifically has been highly scrutinized because it created mandatory minimum penalties for drug use, which has been criticized for disproportionately impacting people of color. This is a quote from the original legislation itself of the Drug-Free Schools and Communities Act. I won't read it out loud, but something to think about here is that in the 1980s, at the advent of the war on drugs, some specific things were happening as it relates to colleges and universities. One is how we were being portrayed in public media. This is the rise of the Animal House style movie and representation of colleges and universities. So public perception was definitely impacting the federal government's view of colleges and universities. It was also the rise of certain lobbying groups, which allowed these type of acts to get passed, including Mothers Against Drunk Driving. There is a handbook that discusses how to implement the requirements of the Drug-Free Schools Communities Act. It is written by Carolyn Palmer and Donald Gehring. The last edition was published in 1992. And this is a theme that you'll hear me talk about throughout, is that there are several guideposts since the act was passed in the late 80s, where the federal government stops enforcement or decreases enforcement, and then there's a spike. And there's usually certain circumstances that cause a spike for the federal government to say, oh, as a reminder, universities, colleges, you have to fulfill these requirements. The Palmer-Gehring handbook pretty strongly stated that universities not only have a legal obligation, but have an ethical obligation to develop and disseminate policies relating to alcohol and drug abuse and provide prevention and intervention programs to protect college students. So as I mentioned, those guideposts, there's the original passage of the act, and then there's a flurry of colleges and universities responding to those requirements. And then there's a lull in the 90s and early 2000s where folks were doing the work at institutions of higher education, but necessarily seeing the level of enforcement actions that we now see by the federal government. In 2011, under the Obama administration, there was a Dear Colleague letter. It's not the Title IX one, but it was during that same year. And there's an interesting overlap here relating to alcohol and drug abuse and intimate partner violence. This Dear Colleague letter did not make that connection, but practitioners often talk about the connection between alcohol and drug abuse and intimate partner violence and sexual violence. But the DFSCA Dear Colleague letter was written by the Obama administration and essentially just reminded colleges, you have to do this, you have to complete these DFSCA requirements. And then the Obama administration also noted, we're gonna continue and increase monitoring. Now, what's important here is that a separate federal office, the Office of the Inspector General, looked into the Department of Education's enforcement of the DFSCA and found that, and you can see the dates there, but really no significant oversight on DFSCA compliance. And what this means is that in contrast to maybe a Clery audit or something similar, the federal government wasn't coming on universities' campuses and asking, where are your DFSCA documents? And how do you enforce those? Until 2011. And that's really when the federal government started increasing enforcement. So what are the potential outcomes of a DFSCA audit? Mostly it's in financial penalties. So the Department of Education can issue civil monetary penalties to any institution that is engaged in substantial misrepresentation of the nature of its educational program relating to alcohol and drug abuse. And the fines were adjusted in 2018. The maximum possible penalty is $55,000 roughly. and that adjusts for inflation year to year. Now, one thing I want to highlight here is that under the current administration and under Obama's administration, DFSCA enforcement usually was nested inside of another audit or review. The most common one is the Jean Cleary Act review, which we'll talk about a little bit later. But essentially, the federal government would come in and audit your Cleary Act, which is a crime statistics act about prevention programs. There's some Violence Against Women Act requirements in the Cleary Act as well. There also is alcohol and drug related policies required in the annual security report, which is required by the Cleary Act. So under the Cleary Act, colleges and universities have to list out their alcohol and drug related programs, prevention programs. And what this means is that when the federal government came to campus and would ask you for all your Cleary crime statistics and going to do an audit, they would also at the same time say, can you go ahead and show us your Drug-Free Schools Communities Act documents? The other common one is in financial aid audits. Oftentimes in financial aid audits, they will ask for similarly Drug-Free Schools and Communities Act enforcement documents. So it's fairly uncommon to have just a standard by itself drug-free schools audit, but normally the federal government nests them inside of something else. And I believe that is because of an efficiency perspective. It's easier to do one audit at one time rather than come back and do it several audits. Also is, at least has been posited that the connection between drugs and alcohol abuse and some of these other acts relating to crime, relating to sexual violence, that the federal government is acknowledging there's a connection there. So the most recent and the biggest enforcement action by the federal government that I've seen is that it relates to Penn State. And this was in 2016. And as I mentioned earlier, this review was both a Cleary Act review and a Drug-Free Schools review. And after a two-year investigation of Penn State's policies, procedures, the department uncovered 11 significant violations of the Cleary Act and the Drug-Free Schools Communities Act, and issued a fine of nearly $2.4 million. Now, that may be shocking, but the letter that the Department of Education put out noted that of those 11 policy violations, only one was relating to drug-free schools, and that came with a penalty of nearly $27,000, excuse me. This is in the letter from the Penn State review by the Department of Education. And I think one of the important points here is that failure to comply with the drug-free schools, at least from the federal government's perspective, it deprives students and employees of important information relating to alcohol and drug abuse, both the consequences and prevention efforts. And that essentially what the federal government is saying increases drug and alcohol related violent crime. So again, as I mentioned before, the federal government is making a connection between drug-free schools work, sexual violence, and other type of violent acts. So we've talked a lot about kind of how we got here, what enforcement is, spend some time on what the requirements are. And it's just important to know that since 2011, there's been increased enforcement and scrutiny. But when it comes to what the federal government is going to be looking for and what we should be having documented, it's really three things. It's the annual notification to students and employees, the biannual review, and then also prevention and enforcement actions. So I'm going to take these step by step and just dissect the requirements and give some key takeaways. So the first is the annual notification. And the annual notification needs to be provided to all students and employees. And I've highlighted and employees there because it's often something that we forget. We forget that this is something that needs to go to every employee on an annual basis. That includes new students and employees, but it also includes employees that have been there for a significant amount of time. Every year, everybody has to get it. It also includes students that are taking any number of classes. That could be one, that could be a full credit load, so long as it's not continuing education. So that's something that's oftentimes missed. And when individuals that are trying to send this annual notification, they should document how they came up with the list that they are sending it to. And then it's important to document that, because when the federal government comes in, or if they come in and do an audit, that information will be incredibly valuable. So what does the annual notification need to include? I've listed them out there. One thing that's important for cannabis specifically is that last, be the fifth requirement of the annual notification, is that it's a description of the institution's sanctions. So that can be employee discipline, suspension, expulsion for students, alcohol and drug intervention programming, but also a statement that the college will impose discipline. Now, this goes back to the original act that we talked to at the beginning, is that the whole purpose and intent of the Drug-Free Schools Community Act, as it was nested inside the Anti-Drug Act of 1986, was to tell colleges and universities that you have to have a program. It can be a prevention, it can be an education program, but you also have to have an enforcement program. So that's really important for a cannabis perspective. We'll talk a little bit about why later. Some other key takeaways for the annual notification is that it has to be in writing. Now, the old handbook that I mentioned earlier, it notes electronic communications are a possibility. Previous to the rise of email and text message as a primary method of communication to students and employees, folks would get handwritten typed documents with this information. Since 1992 and thereafter, there's been a rise of using email communication as a way of getting out the annual notification. It can also be in your, for example, if you've got new student orientation, you can always send it out to a subset of the population in addition to the whole. But the federal government has said that you have to provide reasonable assurances to the Department of Education that if you're audited, that the method that you've chosen to distribute that information made its way all the way to students and employees. So one example of what they're talking about there is that if it goes to everybody's spam folder, that's probably not a good way to disseminate your annual notification. So you got to work with IT, you've got to work with other campus partners, registrar, HR, to get this information out to new students, employees, and all students and employees. So that's the annual notification. Now I'm going to talk a little bit about the second requirement, which is the biennial review. Now it sounds like y'all are pretty steeped in this for those that have been joining these webinars. The biennial review is a mandatory evaluation process that requires institutions of higher education to do the things that are listed on this slide. The primary goal of the biennial review is to determine your overall alcohol and drug program's effectiveness. Now, what is effectiveness? The 2006 handbook, the handbook that I mentioned earlier, offers specific standards for effectiveness. What those mean are designed programs based on a thorough needs assessment of objective data. So you've looked at your data, you've decided what do we need as a campus community. You've established a set of measurable goals and objectives for those needs. So you've identified the needs, you've established goals for those needs. You've implemented prevention activities that research and evaluation has shown to be effective. And you use that evaluation to refine your programs and strengthen them over time. So that's what the department defines as principles of effectiveness. The other thing that the biennial review needs to do is to determine the number of drug-related violations and fatalities on campus or part of campus activities. So this is typically done by asking your human resources department, your housing department, your student affairs, your student conduct department, how many violations have we had over the biennial period, and what have been the typical outcomes of those violations. And again, this is hinting, the fourth point there is that ensuring that disciplinary actions and sanctions are consistently enforced. So this is the will language that we talked about in the annual notification, that the institution will impose sanctions. They're just hinting at it again. And you can include attachments and records of findings. This biennial review normally needs to be reviewed and certified by the chief administration officer of the institution, whether that's a president or a chancellor. And you don't need to distribute it to everybody, but you have to have it available. So this again is showing that the Department of Ed is just saying, this is a tool for campuses to study their program effectiveness. It's nothing more than that. But you could publicly disseminate it or not. Campuses typically post it on a website. That's what we do here at UWM. And so that's an effective tool to do that. You can send it out in the annual notification. You don't have to, but that is an option as well. I talked about the Penn State Enforcement Act earlier. It did describe, the Department of Ed in that review said that Penn State must describe the research methods and data that they use to determine the effectiveness of their program, as well as the responsible official or office that will conduct the review. So one of the best practices is to have a team that looks at these goals and creates the biennial review over time. But what the Department of Ed is hinting at in that is that you have to have one person that's responsible for it and making sure that it's getting done. Now, whether that's your alcohol and drug prevention specialist, that's your health promotions director, your director of your medical facility, your dean of students, that's up to campus, but the Department of Ed has said, one person's got to be responsible for this. What was interesting about the Penn State review as well is that they talked about you have to have research methods to back this up. So back in the day, it typically was just the biennial review was just a spreadsheet with here's how many violations we had and here's what the sanctions were. The Department of Ed is essentially saying that's insufficient, that you actually have to have research methods that look at the effectiveness of this, whether it's survey data, whether it's looking at recidivism, whether it's asking students in your basics program or whatever your intervention program is to provide information and feedback on that. So they're saying that you actually have to have identified research methods and analysis tools. So that's the biennial review. I want to talk a little bit about prevention and enforcement. And really, I divided this up into 5 different areas: programs, policy enforcement, interventions, harm reduction, and motivational interviewing. Now, up until this time, comparatively little work has been done on evaluating interventions for cannabis use in the young adult college population. But we can look to alcohol research to do some analysis there. And that's essentially what I've laid out here in thinking through cannabis programs and policy enforcement interventions. Programming, it can be everything from social norming, so using data to provide or make greater efforts to provide student with information, whether that's their own information from surveys about usage and impact, or any type of other program associated with prevention. Consistent policy enforcement. Now, for my student conduct folks, this is where they come in, using the processes to enforce cannabis usage, possession. At least at the time when I was in Washington State, when they legalized cannabis for recreational use, one of the biggest complications we had was detection. So there were buildings where we had towers of multiple floors, and we would consistently get students talking about smells going through HVAC units and central air. And at the time, at least, law enforcement had detection methods that were generally around, smell and or using the tools that they had if they could actually get in front of somebody. So looking at pupils and whatnot. But the difficulty with cannabis, at least out of the gate, was from an enforcement perspective, this is just a little bit more challenging to to detect, not to detect necessarily, but to pinpoint through your policy enforcement. That has changed significantly over time, especially as more and more states and municipalities either legalize it or decriminalize cannabis use. Consistency is key here. So what that means is that if you have a student that commits a quote unquote cannabis violation, that they would get the same or similar outcome that any other student in that circumstance, depending on the facts. So what the Department of Ed doesn't like seeing is these wide disparities in outcomes. And consistency is also effective from a training perspective for students and for your RAs, for example, because there's a pretty standard outcome for these type of situations. Interventions, one of the best practices, and this probably comes no surprise, everybody in this room, is that using mandated programming post-violation is generally a best practice. Using brief interventions, this is the research that Lee and Kilmer have done at University of Washington, excuse me, and using screening and brief interventions appear at least to be an effective tool for cannabis use. Again, we don't have a ton of research on interventions there, but using, I'm sure we do more updated recently, but using alcohol as the analogy, those have proven to be very effective. Personalized feedback, still a gold standard. Referral to treatment programs as needed. Recovery programs, if your college or university has invested in those, or if you have a homegrown one through a student organization, those can be effective interventions. Motivational enhancement. So I mentioned motivational interviewing at the end. That is a standard that we use at our institution through basics, using personalized feedback there. Excuse me. And then harm reduction. So one of my colleagues from Washington, Jason Kilmer, mentions that for cannabis use, there's lower risk versus low risk. There's no such thing as low risk use. He tells that to students all the time, and sometimes students bristle at him. But essentially looking at environmental approaches to reduce harm, to lower the risk versus just low risk use. That's the research that Jason has done, or Dr. Kilmer has done out of University of Washington. So this is where we get into the societal shifts I mentioned at the beginning. This is research from the Monitoring the Future National Survey results on drug use, excuse me, from 1975 to 2015. From the American College Health Association and the National College Health Assessment. This was issued in fall 2016. And I put some data up there, the first two bullet points from that survey, and talking about students' perception of how their peers use and how students use themselves. Again, this was a research survey released in 2016. The third bullet point discusses the proportion of adolescents and young adults that perceive risk of smoking and just how it's decreased over time. And those trends parallel legislation. I'm going to talk about the 2020 legislation recently, but happening to be from a state, my former institution, where the perception of risk of cannabis usage on our campus directly correlated to the timing of legislation actions to legalize cannabis use for recreational purposes and for medical purposes was pretty direct. And that can be due to several different factors. Again, the view of it being low risk or with low impact, the evolution of laws. It's often said that legal actions do impact legal actions or changes in laws do impact behavior, which is of no surprise, but also geographic and sociocultural factors. This is a cool map from the Cannabis Policy Project, which talks about, or at least shows states where cannabis is legal for adults and it's taxed, states that have medical cannabis laws and removed jail time, It does note DC as a little star on the far east coast over there. DC has legalized possession and cultivation for adults, and also has a medical cannabis law. There are states that have removed jail time for cannabis use for certain small amounts. Those are the black states on this map. And then there are states with just medical cannabis laws. The states that are white in color have no laxed or reduced legislation as it relates to cannabis use. The rest of them have some version of that, is what this map is telling you. And again, that's a great resource from the Cannabis Policy Project. So we talk about the 2020 cannabis legislation. Arizona, Montana, New Jersey, South Dakota all legalized recreational marijuana. Mississippi and South Dakota legalized medical marijuana. DC, as I mentioned, does have it legalized, but doesn't allow sales. So it's legalized in DC, but there's no sales. Recently in our state of Wisconsin, Madison, the city of Madison passed some legislation, or at least advanced some legislation to decriminalize it in their city. And interestingly, in the legislation said, and asked the state to do the same. So just some little creative work done by municipalities or states to try to get cannabis legalized in their area, their locale. The federal bill that has been making the news recently that passed the House, what that will do is it will remove marijuana from the Controlled Substance Act, which I'll talk about on the next slide. It's unlikely that that will pass through the Senate, but it made it through the full House vote and passed there. And Oregon was the big ground shaker in the 2020 cycle. Decriminalized, it didn't legalize all drugs, but it did decriminalize all drugs and legalize psilocybin for supervised therapeutic purposes. Oregon is the first state in the United States in modern times to decriminalize all drugs. And in Washington, DC, they also decriminalized psychedelic plants. So 2 slides ago, I mentioned the Controlled Substance Act, and this relates directly to the Drug-Free Schools and Communities Act and how that can be enforced. So under the Controlled Substances Act of 1970, marijuana is a Schedule I drug. It is still a Schedule I drug, which is reserved for drugs that have a high potential for abuse, and there's no currently accepted medical use and a lack of accepted safety. The schedules are mainly established to determine whether or not there's a valid medical application and whether there's a high risk of abuse. So the federal government is essentially stating that there's a high potential abuse of of cannabis, that there's no accepted medical use treatment in the United States from a federal perspective, and that it lacks accepted safety use under medical supervision. Medical cannabis is also not allowed under federal law. There's no exceptions to the Controlled Substance Act for Schedule I drugs. Now, I get this question a lot, is what about students with accommodations under the ADA? The generally accepted practice is that students would have to store and use them off campus. And disability case law has routinely held that storing marijuana, using marijuana on campus is not something that needs to be accommodated under the ADA by institutions of higher education. Again, there's no exception under the schedule. And while it's fairly rare for individuals to face federal prosecution for medical marijuana use, there is a possibility, and it's a risk that folks have to weigh. So finally, merging these two, the Drug-Free Schools and Communities Act and cannabis legislation, and apologizing for being so blunt, is that despite changes in societal views regarding cannabis, federal law has not changed, which means that institutions of higher education have to have policies, procedures in place to prevent and to enforce, prevent the abuse of cannabis and to enforce violations of cannabis policies. Any college campus that permits the use of cannabis by any staff, faculty, or student, the risk is you could lose federal funding or you could be fined by the Department of Education. And campuses must maintain and continue to monitor, enforce, and sanction student and employee cannabis use as they have since 1989. Now, I got asked this question recently is, how do we get buy-in with some of these programs that we want to do? And it's a great question. One of the things that I think is important as you advocate internally for whatever program it may be, or externally for grant money, whatever it may be, is that this maintains, it is a legal requirement still. And so even though society has changed or is shifting, the way that cannabis use is being viewed, it's still, I think, reinforced that it is a legal requirement that we have these policies, procedures, and practices in place. I'm always a fan of using campus partners to amplify messages. As I mentioned earlier, biennial reviews are traditionally done through some sort of working group. Consider using that working group as an internal advocacy group to talk about what policies and procedures campus could change to make your cannabis related program more effective. But also use your biennial review itself. That's a great place where you have to write out, are our programs effective and what are our goals? It's always a good goal to say, we want to have a more effective alcohol and drug abuse program, whatever that may be. So there's some tools and tips as far as how to advocate for yourself in those spaces. So that's all for me. And I'm sure I hope there's a ton of questions because that's what I'm here for instead of just hearing me ramble on. Thank you all so much for your time.
Thank you so much, Adam, for sharing this content. We do have a few questions that have came in. Everybody, this is your time to submit your questions if you haven't done so already. Please use the Q&A box as we do miss some of the questions as they go into the chat and we don't have the ability to remove them from the chat and put them in the Q&A. Before we get to the questions, we do have a few housekeeping slides. Tomorrow is the 4th session in our biennial review learning collaborative. These sessions do live on after the live session date. So if you are interested in getting involved in them, you can learn more by visiting our website. I have the link on our screen now. We also have our last virtual water cooler chat happening in 2020. That will be on December 16th at 11:30 a.m. and it's titled Wrapping Season. And our last webinar for December and for 2020 is titled Monitoring the Growth and Development of the Collegiate Recovery Field. And that will be happening December 17th at 2 p.m. And you can register by following that link on your screen. And with that, I'm going to turn it over to my colleague, Logan Davis, for the first question.
Thanks so much, Anthony. Our first question, Adam, wants a little more clarification on the upcoming legislation that went through on cannabis that made it through the House, and just so where that is federally. It's made it through the House. What is the likelihood that it's going to move forward?
So it'll have to go to the Senate for a vote, and just based on at least some articles that I've read, is unlikely to pass the Senate. But it does mark some significant progress in that regard, is that it does, that's one of the rare times where it has passed the House and at least made its way to the Senate. So when we talk about societal shifts, that's a big one as well. Unlikely to pass this go around, but the fact that it made it that far is telling. Oh, you're muted, Anthony.
Thank you. This question kind of came in at the beginning. Was the information requested in the Clery Act the same as the DFSCA requirements?
Yeah, so if we go back to that, I'll find a slide at the beginning, but the Clery Act requires that you list out your alcohol and drug abuse prevention education programs in your annual security report. They are different than what is required by your Drug-Free Schools and Communities Act requirements, but the two definitely overlap. Now, I hear this oftentimes, well, we just use our biannual review or our annual security report to substitute for the other. So an example might be, instead of doing a biannual review, we just point to our Clery Act annual security report. The federal government has said no to that you cannot use your compliance with one act as a substitute for the other. So they have to be separate documents, living documents, and the programs are different. That doesn't mean that you can't use the same or similar programs that you talk about in your biannual report as you put in your annual security report. They just have to be separate living documents that you can produce for the Department of Education.
Thanks so much, Adam. This next question is about sanctions. I think when we talked a little bit earlier, it says, is it possible for the sanctions to be less punitive? For example, educational programs and or treatment for those who meet criteria for a substance use disorder?
Yeah, so long as you're consistent, that's all the DFSCA requires. There's no requirement that there be, which is interesting because the birth of the DFSCA we talked about at the beginning was from an act that established mandatory minimum criminal penalties. But the DFSCA has no requirement that you use any type of prescriptive sanction. So you could, as a campus, decide, for these type of circumstances, we're going to use this type of sanction. In some regards, campuses have already done that with establishing basics or whatever is in the NAIAA matrix. So no specific requirement other than you just be consistent and use like circumstances and like facts get similar sanctions. Good question.
Thanks, Adam. You mentioned employees in the biennial review. Should the biennial review include the number of employee violations and disciplinary sanctions de-identified?
Yeah, that's great. Yes, it should. It should include both student and employees. So you'll need to reach out your human resources department and ask them if they've had any disciplinary action relating to employees. It's a lot more rare than students because we have kind of a subset of a population that lives and works on campus. So you should definitely include that. And for students as well, it should be de-identified. It's just aggregate data.
Adam, you mentioned this earlier in answering a question about basics, but what, in your experience, have you seen like cannabis basics course material?
It looks, in my experience, it looks very similar, and I was hinting at this earlier, to the alcohol version of basics. So there's some personalized feedback and some discussion and motivational interviewing and behavior change conversation. So that's how we use it here at UWM, is that there's an initial assessment questionnaire, then there's a conversation, and then a post survey. I've seen campuses use it just in a similar fashion. And at least that's what the research Kilmer has done hints at. There are new programs surrounding basics for cannabis use. I think campuses caught on to this and providers caught on to this. I don't know the acronym off the top of my head of what the cannabis version of it is. I have seen it and it looks a lot similar to basics, just happens to have a very particular cannabis flair to it.
What have you seen happening in actual changes as to how colleges are treating cannabis on campuses?
As I mentioned to the statistics earlier, I think there's a social norming aspect where it becomes a little bit more normal. I have not seen campuses just outright stop enforcing or stop preventing or stop educating. But perhaps it's just a little bit less pardon the pun, but on the back burner than was previously. And I just think that has largely to do to the way things have been shifting societally. I think it would be odd for a campus to come out, at least publicly and say we're not going to enforce our cannabis abuse policies just because of the risks under the federal government, as I identified earlier. But there is, I can just tell you from someone that works on campus, is that we just don't talk about it as much as we did anymore. When I was in Washington and the law changed, that's all we talked about was how are we going to educate students on this? How are we going to enforce it? There's no way we can enforce it. And then it just became normalized over time. I think for what it's worth, we got a lot of fear when the law changed that, oh gosh, it's going to drastically increase your numbers. And at least in Pullman, Washington, which is the quintessential college town, it didn't really change much. And the reason being is that a large number of students that were violating our cannabis policies were under the age of 21 anyways, which was the state cutoff for legal usage. So there wasn't a significant impact on our numbers or data. But what was more interesting is that it shifted the percentage a little bit. So instead of, I don't remember the numbers exactly, but this percentage of alcohol use being much higher of our overall drug and alcohol abuse numbers, it shifted. So marijuana use became more prevalent after the law changed. But as far as the raw number, the number in total, it didn't really shift that much.
Adam, a quick follow-up question to that. Someone they actually identified as a naive question, but what's stopping a campus where you talked about is just saying, we're not going to follow the federal policy, we're just going to accept the fines and not follow the regulations. What other things other than the fines are stopping campuses from doing that?
So the first and the biggest being is that if a campus outright said that, it's the same hammer under Title IX, which is they could withdraw all federal funding. So that includes grants, this is a possibility. I'm not saying it's a likely outcome, but it is a possibility. The other thing is that it could increase the potential that a student that is using cannabis on campus and gets injured, and there isn't a response mechanism associated with that the student, their parent, and this is just Adam, lawyer, risk averse talking, could sue the university saying you're required by federal law to have these programs in place, you don't, and therefore my son or daughter, my student got injured. That would be an interesting claim, but that is a possibility as well, just as they're called torts, like a tort of negligence, essentially. But the big hammer from the federal government is the federal government could ostensibly, and this could change in T-minus 40 days or whatever, could say, we're going to withdraw all your federal funding.
Thank you so much, Adam. For the annual notification, federal law is required. However, if we are located in an area that has decriminalized cannabis, should that law also be included in the annual notification?
Good question. You have to include federal and state laws. Most campuses also include local, if there's any significant changes to local laws. So for example, when I was in Washington, we would say the federal law says X, Y, and Z, and the state law says the following. But then we would highlight to folks, especially that were getting the annual notification, that even though that cannabis was legal recreationally for those over the age of 21 that were using inside the privacy of their home, that it was still prohibited on campus.
Adam, somewhere along the same lines about it being decriminalized in many states or legalized, depending on the words you want to use, is how do we have this conversation with students? That it is still considered a Schedule I drug, which in many states will say that it has no medical or health benefits, while some states are passing it with medical purposes, and then some states that have passed it legally, and then federally it is still legal. So what does that conversation with students look like?
Hard. It's a challenge. And it's a great question. So in my student conduct days, when the law changed, I had more and more students that wanted to come in and argue that with me. And from a policy perspective, we would just say, at least from a student conduct perspective, our philosophy was get them through the process, uphold our procedures, and then get them to the experts that really are the pros in those conversations, which are the alcohol and drug intervention specialists, our health promotions folks. Because student conduct folks, as much as they, as much as we'd like to think that we're alcohol and drug intervention specialists, we definitely are not. So try to get them to the expert to have those conversations. It is a challenge, and just saying, hey, it's illegal under federal law, it doesn't really ring true to students. I would often pivot that energy and ask them to, write me a paper about this, because oftentimes an outcome in a student conduct process is write an educational paper, right? That's a tool that we have. And I'd say, go research what the federal law is. You have to have awareness of it. You have to have knowledge of it. What are our policies? And then make an argument to me of why we shouldn't have this. Why we shouldn't have this criminalized federally or by the state. So I would oftentimes re-engage that energy in a different facet. And that's the educational process that is the student conduct process, or as it is intended to be. And then I would engage in students in a back and forth, kind of in a Socratic way of asking questions, getting feedback. So that's it. I would also have them research, the possible health risks, because I think the perception that students carried, especially when the law changed in Washington, was this is a no risk activity. So that goes back to what I mentioned, Dr. Kilmer's research, and what he tells students is there's no such thing as low risk, there's just lower risk. So I'd have them go research that, and that's a student conduct trick, I guess, is to try to redirect that energy, because it doesn't work to tell them, this is the black and white rule without offering them an opportunity to teach themselves and educate on it. So anyways, that's a couple ideas there. And I totally appreciate where students come from in that perspective, because especially with how things shifted in this most recent election cycle, it's hard to look around at the states that it is illegal and not question why, at least from the student's perspective. So I totally understand where they're coming from. So just consistent enforcement and messaging and saying it's still against the law on campus. You're still under the age that you could even use it if there was a state where it's legalized. So I hope that answers it. It's a great question.
Thank you so much, Adam, and thank you so much for sticking around to answer all these questions.
Sure.
We do have a lot of questions, and we'll try our best to get to all of them. I do want to direct folks to check out the chat, as there's some fruitful conversation happening and resources in the chat as well. Another question, Adam, can the annual notification utilize emails containing a clickable link to the information, policy, sanction, etc., that is required to be shared?
Yes. You can craft that email. It can go to a website. It can go to a document. Ours, for example, doesn't have the policy written out in the email. It just goes to a link. That's just to increase readability. So absolutely, you can just link it to a website or another location or a document where that information is stored.
Thanks so much, Adam. This question is asking if you can go back in your slides to the one that mentioned the guide. I think it was from 1992 about the DFSCA. If you could just go back so they could see that title that was mentioned. And then, so I figure if we go back and then we can get to the next question there, so people can then look at it, look it up on their own.
Yep. There we go.
So this question starts, we have folks who are reluctant to release students with medical marijuana cards from their housing contracts so they can live off campus because they believe this would be seen as condoning or permitting use. Thoughts on the legal viewpoint for this workaround for students?
That is permissible so long as it's equally enforced, meaning that for every student that was eligible for that, they would have to be allowed the opportunity for that. I would work really closely with your legal counsel on any type of shift, but as I understand it, that would be an okay response. But I am not aware. I don't know of any campuses that I'm sitting here, and that doesn't mean that there aren't any that does allow that. But I could be wrong there. So.
Thanks so much, Adam. This question is saying that their campus does their review on odd years, unlike most campuses. Could that put us at risk for penalties if we aren't doing them at the same time as other campuses?
No, there's no requirement so long as it's every 2 years. I think most campuses do them on even years, but it's either no risk or a low risk of any type of scrutiny there, just so long as you're doing it every 2 years.
Is there anything that a campus should be taking into consideration for sanctions if campus PD does not currently have the ability to test THC levels to differentiate between hemp?
That's a good question. I think the student conduct folks, or the student conduct person in me would tell you that we take every case based on its facts presented to us, and so try to remain neutral in that regard. So that means that if there was if I'm using the alcohol example, the difference between a DUI and an MIP, or a minor in possession and driving under the influence, is different in the eyes, or can be different in the eyes of a conduct officer, just as similarly as depending on the type of use, the percentage of use, the method of use of cannabis. So there can always be differential outcomes for different facts. The important thing for the biennial review and showing consistency is that you're consistently doing that. Meaning that if you have a policy or practice that hemp gets a lower sanction or penalty, that you're doing that throughout. So that's all from the DFSCA that they would tell you. It's a great question.
Thanks so much, Adam. This is just a quick question on violations, and just how are they reported, and any other information that you have that might be relevant about violations.
Violations as,
I think, to the DFSCA. So like they're not following just what is prescribed.
Yeah. So someone could complain to the Department of Ed, but what is more traditional is they catch it when they're doing another audit. So it's not necessarily someone is complaining about it. It's just they're doing another audit. They're doing a financial aid audit, and they say, "Oh, by the way, while we're here, can you show us all your drug-free schools work?" So it's. I have not been part of a review that was instigated because of a complaint, but I suppose that is possible. What is more likely is the department is already on your campus, looking into other things, and they go ahead and say, well, we're just going to loop this in and ask. Again, the Penn State one is an example as being common as the Cleary and drug-free schools enforcement.
Thank you so much, Adam. We just have a couple more questions that we'll try to get to. Any ideas on addressing out-of-state students with a medical card, but the card is for a medical issue not approved in the state where the college or university is located?
Yeah, prevention and awareness is key here. So messaging out to students, especially if you have a large population that comes from an area that allows that type of usage. But again, just letting them know as a policy violation is a policy violation is a policy violation. So if a student were in my office from a neighboring state that had a different law than the state I'm in, I would remind that student that as a member of the community you accept and you should be aware of, or should educate yourself on the policies and the laws as it relates to cannabis use, and as an institution, just consistently enforce. But again, I think at the heart of your question is maybe how do we message around that? So anyways, there is a possibility of that happening, especially if you're in one of those neighboring states back on that the map that I showed, and just reminding students that this is the policy and the practice and the law in the state.
Thanks so much, Adam. This question is saying that while this presentation focuses on higher education institutions, what do you know about similar parameters regarding the DFSCA in secondary schools, K through 12?
Yeah, this is going to be easy. Nothing. I don't know. I don't know anything. I'm more than willing to admit when I don't know something. So I have no idea. It's an interesting question, and I definitely will look it up in my abundant free time, but I don't know off the top of my head.
Thanks. We have one last one that I want to get to. I know we're running over and people are having to leave. So I'm going to read this one and make sure I get it. And this will be our last question that we get to. And this person is saying that their institution in New Jersey has a sizable population of students living off campus. Does a student's status as a student affiliated with an institution receiving federal funds preclude legal use of recreational cannabis, even if the use occurs off campus? How does campus policy on AOD thread this needle?
Okay, you're going to hate me. I need you to repeat that one more time.
No, you're good. And you might be able to view it as well. It's the only one. If you click the Q&A on the bottom, if you can find the toolbar, because I know I just want to make sure we get it accurate.
Oh, okay, yeah. Oh, okay. Okay, I can't find it. Hit me one more time.
No, you're good. So here we go. It says their institution in New Jersey has a sizable population of students living off campus. Does a student's status as a student affiliated with the institution receiving federal funds preclude legal use, even if it is off campus? And so how does the campus policy thread this needle?
It would depend on your policy, but generally, because you're obligated to follow federal laws, that if you become aware of a student living off campus that is using, even if it's in accordance with state law, you would have to enforce that. You would have to run that through your policy and your student conduct process. Now, depending on your campus population, that could be rare, because generally in these states that have legalized or decriminalized, you have to be over the age of 21. But as far as DFSCA and the Department of Ed is concerned, is that if you become aware of a violation of federal alcohol or drug law, you need to enforce it.
Awesome. Thank you so much, Adam, for staying around. And thank you so much to all of our attendees. That is all of the questions we have. And so that concludes today's webinar. I think we're going to go back quickly to our upcoming events that we have coming up, upcoming webinars and water cooler chats. So thank you all so much for your time and trusting in us to provide great space and education for you all. And Adam, thank you so much to you for knocking it out of the park and just providing exceptional content for today. So thank you all so much, and we hope you have a wonderful rest of your day.
Thanks, y'all. Have a good one.